Welcome to the Codecast podcast. Real-world insights for your daily medical coding and billing processes. And now, here's your host, Terry Fletcher.
Hello, everyone, and welcome to the Codecast podcast. My name is Terry Fletcher. Today is the 140th episode of the Codecast podcast. And I'm pretty excited about it today because we also hit 140,000 downloads and listeners. So we're pretty excited about the growth that the Codecast has seen in the last just 6 months. So thank you for everyone who is listening, who's sending some positive thoughts our way. I really, really appreciate the fact that everyone is still so involved in some of the information that we're putting out there. So again, this is a really good day. And I am recording today on the first day of summer, so that always makes it a positive day. My daughter likes that because she says it's her day since her name is Summer. So always a good day when you get your name involved in there. So today I wanted to bring you a topic that I don't actually speak about often, and I think I really should. I talked about it recently on ICD-10 Monitor, a Talk 10 Tuesday live session that turns into a podcast that I do as well. But I wanted to expand on it on my own podcast because I think it's important now that we're coming up into contract negotiation season. You know, that's coming in the fall. And so payer contract negotiations is definitely a topic that if you're in the billing office, coding department, you want to be involved in. And a lot of times it's just physician and maybe your administrator. If you're in a hospital, it's usually the C-suite people. And it's tough to basically try to understand some of these contracts and really know how to navigate through them when it comes to negotiation. So I want to give you some of that insight, hopefully give you some information so that you can put together a compliance manual that actually has details. Because when I spoke about this briefly in 2018 on the Codecast, it was more about, having a compliance manual in your billing and coding department, knowing how to facilitate that, making sure there were checks and balances. But how can you do that if you don't know what's in your contract? And many practices that I go to, because I am also certified in practice management, not just in coding and billing, but to look at the overall operations, I will ask a question saying, so what does this contract allow for, let's say, EKGs, or what does this contract allow for fracture care in the office? Or if you're a neurologist, what is this for EMGs if you're in the office versus in the hospital? And it's funny because I get many practices that say, we actually don't know. Then we start getting into technical terms like MIPS and MACRA and value added care, and I get deer in the headlight looks. And so it's very important that we really look to see about negotiating these contracts. And with the contracting season coming late fall, actually some are starting in October, that you at least have a place to start, some insight in how to kind of get into the art of negotiation, which is really what it is. Now, if you're interested in more of a kind of a classroom style or webinar series, I am teaching one for ICD-10 University on July 30th on payer contract negotiations. So feel free to take a look at that. It'll be linked on my website as well. You can see it under our offerings. So just some things here today I want to talk about in more of a general sense and give you some insight on how to negotiate a contract post-pandemic. I mean, let's face it, we are going to have, I would say, some payers that are going to use this situation to their advantage, not to yours. So whether you are a novice or a seasoned negotiator when it comes to contracts, these can be complicated and difficult to interpret. Even with an attorney or a consultant like myself by your side, I've walked into physician and medical practices through this process. I've walked them through several times over the past 25, 30 years. And there are always negotiating points to keep in mind during these debates. And that's really what they come out to be, because there's contract language, there's inclusions, there's exclusions, there's coverages, there's payment. When commercial payers and providers come to this negotiating table, we're going to do it at the tail end of a pandemic. Well, at least that's the hope. And the unprecedented financial and public health challenges we're going to face in this situation is going to affect the type of agreement that you're going to be able to get. So we start by looking at trends. We look at certain negotiating points. We look at things that happened during the COVID pandemic and what's still happening. But when you look at negotiations, negotiation, let me talk to you about what that means. That is a formal discussion between the people who are trying to reach an agreement, and it's the act of negotiating. So it really involves each party trying to gain an advantage. And by the end of the process, who has the advantage? So the physician's role, or a coder's role, let's say, or a professional's role in healthcare, is to know how to effectively negotiate these contracts. You're going to have to look at cost analysis. That should be performed in an organized way to establish dollar value on tangible and intangible items. You'll need to have a clear understanding of business principles, current market trends, and the cost really of delivering quality healthcare. So healthcare contracts, again, are legal documents. So once you've had that negotiating period, you may have to have an attorney look at it. But many physicians sign these contracts without any negotiating. I know that several healthcare organizations, who I will not name, try to get the physician to sign on the dotted line without really looking at what the details are. And some payers will say, this is what we're paying in your market, take it or leave it. And you just have to understand that the terms in the contract are not absolute until you sign on that dotted line. So we have to create and demonstrate value in terms of data, quality care and how it's cost effective, long-term goals that benefit the team as a whole. Even if your practice is run efficiently with low overhead, your payer contracts, if they're not properly negotiated or worded, this can be a loss of revenue for you. Think about telehealth, and I know I hate that word now, but let's just think about telehealth, what it was during the pandemic and what it is until the PHE is ended, but what it could be post-pandemic. New contracts, this is a way for providers really to shore up some lost revenue. Though it's case by case, providers need to really look at a quarterly report. They need to look at the half-year report and understand that COVID, it is really having more an effect on the physician, but not really on the payers, because they didn't have any of the elective cases that they used to have. And they're still getting paid premiums by their subscribers and by their stakeholders. So you have to look at your financial footing as well. There's also a saying that I like to use, and not everybody remembers this. I'm old school. So it's something called force majeure clauses. And what this is, it's a legal concept that I learned from a really good friend of mine, an attorney that we do a lot of work together. And it's an old concept saying that a party or both parties in a contract may be excused from performing obligations outlined in the contract if an unforeseen circumstance makes it impossible or impractical to do so. So these clauses only work when events are unforeseen. Think about the pandemic. So it wouldn't apply to current negotiations, but if we had a second wave or something that could happen, that's how you have to give more thought in how to protect your physician and the physicians that are listening, how to protect yourself. And so you want to understand maybe expediting payments or waiving prior authorizations, for example. That's something that you want to have written into your contract language. And I could see increased discussions around shared savings into value-based agreements. You know, in upside-only risk payment arrangements, providers get to share in savings if spending comes in below a threshold. But providers in upscale-only risk agreements, so in risk management, they may actually see a bigger payment out this year because of how many services were deferred because of COVID-19. However, most shared savings contracts have quality thresholds that have to be met before a provider can share in the savings that the payer gets. So you have to read the fine print of these contracts. And so I just wanted to give you some points in negotiation. Again, in a general sense, this is not a training session, but just something for you to think about. Hopefully some of you are now back to driving to work and you're listening to the Codecast, or you're starting your workday, and this is where you're saying, you know what, first I need to get my Terry Tuesday information on some things that are coming up. And I know a lot of us are basically just, a lot of you are getting back to work. I haven't missed a beat. I've been actually going into my office since it started. I haven't had many days working from home, maybe 3. But I'm lucky. So I got an essential healthcare worker waiver from my city. But what's interesting is that you really have to start looking at things outside of the here and now. You have to look at the future. You have to look at, again, this climate of contract negotiation and what you can do to navigate these waters and know what you're in for before you engage with the payers. If you don't think they're preparing, just guess again. I'm already hearing hearing it from some payers that want me to help them negotiate a contract with a physician to their end. And I'm like, you've got to be kidding me. So I said, I'd be happy to be kind of an arbitrator and sit down with both sides, but it's going to be equitable for both sides. So we want to make sure that we have that equal footing. So here's some tips, and I like to make lists, so I'm actually going to give you 10 points. I know somebody said, why don't you do this as your top 10 Tuesday? Well, that's next week, and that's going to really focus on HIPAA. We have some new HIPAA information we want to be clear about, especially with OIG saying some of the relaxed flexibilities are going to be rolled back. So this week, we're going to look at some points of negotiation and with payer contracts. So first of all, it's a business, it's not personal. Now, I know many practitioners take the process personally, and I understand that it's your livelihood, but the truth is this is part of doing business. Post-pandemic tensions will be high. Payers may try to play on your sense of we're all in this together, but remember their profit margins and yours. We're definitely not on the same playing field as being in this together, as several payers have seen basically their highest profits this year with the nationwide quarantine order and the lack of elective cases. They are pretty much in the black. So that's something you have to always keep in mind. Also, know the rules of engagement. I think I should have made this number one. Who's going to be accessing you through the contract? Self-insured plans, fully insured plans. Workers' compensation is always a surprise. I see people all the time and practices all the time saying, wait a minute, we're part of a PPO or EPO, and that EPO added an additional discount on our already discounted workers' compensation services. And if you sign that in your contract, there's nothing you can do. Is it a lease network? Will it have proprietary rules of engagement? What will you need to be aware of here? So understanding that is going to be important. Is it going to be one of the leftover Obama exchange plans? So understand that. Number 3 would be understand authority levels and limitations. This is one that I have to relate back to what you do in your office. Maybe this will kind of resonate with you. So have you ever discussed basically some myriad options during a consult for an elective procedure with a patient? The physician thought they had explained something sufficiently for a decision to be made. And then at the end of their consultation, they ask for a decision with the patient. Can we go ahead and schedule your procedure, your surgery? And the patient says they need to check with another party. So their husband, wife, mother, sister, etc. Well, why didn't you know this up front that was going to be the case? Did you ask before the conclusion of the consult? Did you ask when the patient was considering having the procedure, or how many previous consults they had? Would have helped you to know where you stand on your level of authority with that person that you're negotiating with. Well, translate this to negotiating with payers. This is a must. You don't have extra time to spend in your office or away from your office if they're having you come to their office. I think most of these negotiations, either have them come to your office or do it virtually if you can. But you need to be treating patients if these are, if your practitioners are listening. Insurance payer negotiators or provider relations representatives, these people are salespeople at the first level. They're only given a certain level of authority for discounting, financing, additional offerings, etc. So find out first, early in the process, what their authority is, and basically then you can eliminate a lot of wasted time by cutting to the chase and insisting on speaking with someone who may have the ultimate authority to negotiate to your satisfaction. I make that almost a mandate. So number 4 is something that I talk to physicians about before we even walk into the negotiating room. So number 4 is, are you willing to walk away? Know before you go in to negotiate which procedures or terms that, if not met, will cause you to walk away from the table. Know which ones you're going to use as concessions to get what you really want. Ask yourself what your practice can and can't live without. You're not going to get everything you want. Remember, this is a negotiation. So in the end, you will have to compromise on some points. And so that's a big thing to think about. What can you walk away from? You're not going to get everything. Number 5 is read everything. Read the contract very carefully. I've read some of these contracts, and some of these clauses are so one-sided. Amendment provisions, a definition of medical necessity, rate changes, timely filing provisions, prevailing contract and termination language. Also insist on putting everything in writing during the meeting in preliminary format. The worst thing that can happen is that the deal changes once you've arrived at a verbal agreement. A negotiator may make promises that he or she can't carry out. You never know whether these issues will come up until it happens, and then it's too late. And these type of issues can permanently destroy future relationships with your payer's representative and also with the company they represent. So here's an example. Let's see how such a situation might play out in your practice. Have you ever quoted a price to a patient for a specific elective procedure and the patient relates a totally different scenario or treatment plan than the one that you reviewed with them? So the treatment and the fee associated with it isn't even close to the one that you quoted to them verbally. But if you put that quote in writing with a copy to the patient and one in the chart, you then minimize the chances for ill feelings among the parties involved because they've either signed off on it or you now have it in person. The confusion isn't really any one person's fault necessarily. But remember the old saying, what I said is not what you heard. The identical words were spoken and heard by everyone, yet the interpretation may not have been identical. So there's an old saying from a movie studio owner, Samuel Goldwyn. He said, an oral agreement isn't worth the paper it's written on. And when parties fail to live up to an agreement, proof of negotiator's intent is critical. First, it enables you to avoid the he said, she said bickering that helps those in charge of resolving the dispute so that they know what's intended. It's called keeping the other person honest. Why do you think in the last 25 years of me doing any kind of education, especially on coding and billing and reimbursement, with how fluid things are and they change, I record everything. I record not only, as you can hear, my podcasts, but I record webinars, I record live seminars. I actually will not do it now unless I record it, because 9 times out of 10, I'll get an email from somebody saying, you said this, and I'll go back and say, I did. I don't remember saying it. It's not in my written material. And then I'll go back and listen, and it was never said. So it's what somebody heard versus what was actually said. State laws apply. That's number 6. Be aware of your state laws and how they affect the way insurers do business. So, for example, be aware of timely payment rules and take-back rules. And let's face it, public health emergency rules if we ever find ourselves in this situation again. And also, you might want to negotiate something about executive orders from governors that are politically motivated instead of healthcare motivated. I would absolutely be putting that in the contract language that overrides anything that a local government official who is not a healthcare professional is allowed to do. So you have to really understand that contract language will hold up in court over a verbal order from somebody else that is not a healthcare professional. Number 7, be aware of the contract term. This is huge. Many payers want to sign you to a long-term contract, which starts at 3 or more years. And you have to understand, does your contract have built-in increases to keep pace with inflation or other considerations? Most do not. So they want to keep you at a certain level of fee schedule for a certain time frame. That's why I also, when I contract with people for audits and things like that, I'll say, okay, well, until you pay this contract, this is what it is. And I'll get a lot of hospital systems on times, or just a few, I shouldn't say a lot, but I'll get a couple hospital systems that will contract me for an audit, and then I don't hear from them for a while, and then all of a sudden they say, oh, sorry, we were putting in a new hospital system or an EMR system or whatever, and then I'll hear from them. Actually, it's funny, I heard from one 3 years later, and they said, then they signed their contract. I said, well, I just want you to know, my rates changed, so what I might have offered you 3 years ago is different now, so you want to also understand that you're in charge of that contract term. If you want to try it for a year, 2 years, whatever, but just be very conservative in that approach. Number 8 is make sure that your rates are clear. If the rates are based on a proprietary fee schedule, you need to know what they are before signing. If the rates are based on Medicare fee schedule, is it the current fee schedule, prevailing fee schedule, or another year? If current and prevailing fee schedule, what do you do if the rates drop significantly? Are there multiple plans under this payer, and do you have the fee schedules for all of them? There may be EPO, PPO, ACO, and other administrative and contract provider adjustments, and you need to know what those are before you sign on the dotted line. To help reveal the rates and overcome payment inequities, I suggest creating a utilization report. This will help you capture and review data. So using a spreadsheet, determine the frequency of a current procedural terminology code, so a current CPT code, and the number of times it was billed to that payer. multiply that by the current payment amount, determine the break-even point. This is done by adding overhead and physician compensation by total frequency of all CPT and or HCPCS codes for that payer. And the results are a weighted average cost. So compare that weighted average cost to the weighted average reimbursement. It is essential that when you're looking at this, that payer contracts are carefully reviewed for their fee schedules and the provisions that can alter the net revenue that your practice generates. So research has showed me that larger corporations have an added advantage in using volume of providers that service their clients. If there are clauses in the contract that the insurance companies will negotiate that can affect your break-even point, a letter of intention to discontinue the contract should be sent. Number 9 is know what isn't covered. Be clear on what the contract is not covering, what procedures are not covered, and procedures with very low reimbursements or multiple procedures on the same day, or do they require you to use a specific outside vendor, or limitations on therapies. So you might have frequency guidelines, possibly pre-existing condition issues, specialized care such as acupuncture or certain diagnostic services. It would also help you to know the issues of concern for the payer. So for example, if the payer's concern is with high-use ancillary services, it would help to point out how effectively you manage the use of these services. You can show cost control and forecast the predictable costs, share your practice data showing compliance and improved patient outcomes, and then you can demonstrate the efficiencies that reduce cost. And the goal of this business relationship between you and the payer is you're trying to get them to understand that you're both trying to provide cost-effective health care to the patient. And so you want to show the payer how many of their members avoided hospital readmissions because of the effective quality health care that you provided. And if you would share information like this can only help your negotiating position. And then number 10 is prepare. And prepare is, it's a word that actually, if you look at preparation, that's also known as due diligence. It requires a lot of energy and commitment. And to paraphrase an old cliche, the 3 most important things about a negotiation are preparation, preparation, and preparation. So proper preparation certainly allows you to understand the process and if it's worth pursuing. You want to be ready to ask questions, but you need to also demand answers in a respectful way. Today's patients, vendors, and yes, insurers, they're more educated than ever before with the availability of information from the web. So you can obtain many varying opinions, positive and negative, by doing some online research, but at least you have the information and you can make your decisions based on that. And hopefully you're using authoritative references. And did the insurance payer prepare a dialogue for you, or are they just repeating what every other physician is told? Your office is unique, and so it demands individualized attention. Also, just in closing on this topic, it's advisable to start the discussions with payers approximately 90 to 120 days before your contract term ends. This helps tremendously when the communication is channeled through one individual from the health plan with whom you have a business relationship with. So in preparation for your negotiations, you need to set a bargaining range that includes your target goals, your optimum and minimal goals. Your optimum goals are where your terms are ideal. The minimum goal is the point which absolutely has to be met. The target point is where you would like to be at the end of the negotiation. So I would advise that you meet face-to-face with the payer if that allows, present clear data and request for change, and listen to what the representative has to say, which that's important in any negotiating situation. I'm noticing with everything going on in the world right now, everybody's talking, but nobody's listening. And so when you're bringing it back to your contract negotiations, make sure that you have a person that is most experienced with complex negotiations. If you don't have somebody that can negotiate for you, hire an outside consultant. We can do it. That's my job as a consultant. Find that consultant that you're comfortable with so that they know to ask certain questions that could possibly affect cash flow. One of my sticking points when I negotiate contracts for providers is how can the prior authorization process be made easier? Okay. Also, can the claim or the time period for submitting a claim, can that be extended? Improvement and ease of the appeal process is helpful. I want timely payment and interest on late payments needs to be clarified. And so This will help you really to understand your revenue generated and could possibly increase reimbursements anywhere from 3 to 10%. Also, where does patient satisfaction in surveys, where does that fall in your high marks for outcomes and your negotiation tool? I've noticed that many contract insurance and commercial plans use those to drop providers from their contracts, but you could flip it to a positive and to your advantage as a negotiating point for your patient community and being the face of the payer based on your positive patient satisfaction surveys. So again, there's a lot of that goes into contract negotiations, but hopefully this is something that you can take with you and you can take back to your physicians, and it'll be helpful to you. So the Codecast podcast is also brought to you today by FormStack, a secure workplace productivity platform built to produce solutions to the everyday work that slows organizations down. FormStack is a data collection and management tool that allows you to build forms and surveys in minutes and store your submissions in an encrypted database. FormStack maintains HIPAA, GDPR, PCI, and WCAG compliance. If you're looking for a hassle-free way to revamp your data collection process, look no further than FormStack. Visit formstack.com/codecast to learn more and sign up for a free 14-day trial of their solution. formstack.com/codecast. Okay, so let me get into my coding question today. And where am I here? So my coding question was interesting. It says, Terry, beneficiaries are provided with vital signs, and is it sufficient enough to satisfy the portion of the annual wellness visit, the AWV, when conducted via health, if it's, the patient is the one that's giving it to us. So this came from a office hours call from Medicare, and they said if the beneficiary is at home and has access to the types of equipment they would need to self-report vital signs, so a scale for weight, a blood pressure measurement, device, and if the visit meets all the other requirements of the code description, this scenario would satisfy the requirements for purposes of billing the AWV code via telehealth. So this is interesting. I'm looking at this, kind of as post hoc guidance, because we had such a speed which CMS moved to extend telehealth treatment. And I'm saying, well, what if a patient just gives a verbal over the phone of what their height, weight, temperature is without actually having these devices to be able to provide the requirements to self-report? And so this is going to be interesting when the audits come out. But think about that if you're using vitals or the constitutional exam based on just telehealth appearance of the patient when it's something normally done by the provider on an in-person visit and the provider has no chance to check the patient's work. That's why I'm having such a hard time with all these people saying we should keep, telehealth as it is now forever. That's not the gold standard of care. It's basically taking the patient's word for a lot of information and a clinical scenario where you don't know what the patient has access to as far as the type of equipment they have to make sure, and insight to make sure it's accurate. So that was kind of an interesting question that I really appreciated. Our coding question is brought to you today by Modern Healthcare Magazine, award-winning healthcare business news, research, and opinion, modernhealthcare.com/subscribe. So I know I'm going a little long today. I've been actually averaging about 22 minutes, but I had a lot to say today. So I'm glad you're sticking with me on all this. But I wanted to remind everyone that the 2021 E&M changes, they're only 6 months away. And you really want to, with 6 months to try to prepare for this, it's time to start your training for you and your staff. At least get a preliminary webinar under your belt. So I have a webinar series on demand. You can see it on my website at terryfletcher.net. Also, my blog page on the same website gives you an article on those changes, and then we'll take you to a registration page at the end if you want to order that web series. So it was going to be 4, now it's 3, just we combined some services, but they're on demand. So as soon as you register for it, you can immediately get the link to listen in and get your PowerPoint and the presentation. That is also, it's on demand, so you'll hear my voice, and it is a training session. But don't wait. These changes are very detailed. detailed and will have a heavy impact to all medical practices. And I see most people saying, oh, it won't happen. Yes, it will. It's already part of the CPT book. It's already going to be put in there. And Medicare is already telling us to use them for, some of the guidelines for certain telehealth services. So it's going to happen. But again, we're only 6 months away. So get your training done. I want to end today with my personal tidbit that's actually positive and very fun. And I'm excited to announce the Codecast has received the Best of Healthcare Award from my local city here in Laguna Niguel, California, for the third year in a row, and for my contributions to the healthcare community. And I really appreciate that. So that was exciting for me. We got it in 18 and 19, and I just got my plaque for 20. So, and in celebration of that, I would like to offer those of you in the healthcare community, so coders, billers, compliance people, health information, people that are out there, have health information management, compliance, I want to offer you a challenge. So I give scholarships every year to healthcare professionals trying to get certified but can't afford the cost of membership and the exam. I don't even think I've announced it on my Codecast before. They're $500 scholarships. I usually give 5 of them. So about $2,500 a year. And if you want to be considered for one of these scholarships, drop me a rating and review on iTunes or your platform, wherever you listen to the Codecast, along with an email to me on what certification you want to get and why you would like to be considered for that scholarship. I'll pick a winner and announce it on July 14th. And so that is in a month. So that's 4 weeks away and on the episode. So you have 4 weeks of Codecast to think about this. But it's open to anyone wanting to boost their knowledge and career in the field of coding, billing, again, HIM, compliance, whatever. But I'd like to offer that to you in celebration of what the Codecast is doing out there and how much I appreciate all my listeners. So thank you again for making this such a success for me. I love doing this. Don't forget to check out my Business Collective podcast. That is also out there doing really well if you want to get into being an entrepreneur. So everyone, make it a great Terry Tuesday. Thanks for spending some time with me, and make it a great day and a great week. Thank you for listening to the Codecast podcast.
For more information on medical coding, billing, auditing, and compliance, including how to hire Terry, follow Terry on Twitter @TerryCoder1 or visit her website at www.terryfletcher.net. Podcast producer Joe Kuzma. Music producer Dassassin Music.